Okay, welcome back. This is the final video in the case initiation series for establishing child custody. So let's review what we covered today. To initiate your case, you need to fill out and file the following forms: the sensitive data form, also known as the confidential sensitive data form, the summons, preliminary injunction, petition to establish paternity, legal decision-making, parenting time, and child support if paternity is at issue in your case. Otherwise, if it's not, then just a petition to establish legal decision-making, parenting time, and child support. Your proposed parenting plan, the order and notice to attend parent information program, and your proposed child support worksheet. So fill out all of these forms, perfect them, and then you would e-file those in the county that has jurisdiction and venue and is the proper venue for your case. You'd file it in that county. And once it's processed, you'll be able to get copies of the court stamped documents. At that point, you need to serve copies of the documents you filed on the opposing party, on your co-parent. And you've got these options. You can do acceptance of service, where you meet with your co-parent, you hand them a copy of the documents you filed, and then they sign the acceptance of service before a notary or a court clerk. And then you e-file the signed acceptance of service with the court. And at that point, service is completed. Another option is using certified restricted mail. So you'd make a copy of all of the documents you filed. You'd mail those to your co-parent via certified restricted mail. And if they sign the green card, then you would e-file the affidavit of service by certified mail and attach a copy of the signed green card to your affidavit. You can also attach a copy of your receipt from the mailing. Third option is a process server. You can hire a private process server or a police officer or sheriff's department to serve the papers. And upon them completing service, they would e-file the affidavit of service, and that's when service would be complete. If your co-parent is avoiding service or you can't find him or her, that's where you could utilize the motion for alternative service and look to use alternative service or publication. All right, once service is completed, then if service was completed in Arizona, then the responding party has 20 days to file their response to the petition. If they were served outside of Arizona, then they have 30 days. And when they respond, they need to draft and e-file the sensitive data form, their response to the petition, their proposed parenting plan, and their proposed child support worksheet. Once a response is filed, the court will most likely set a resolution management conference 40 days after the response is filed. So this would be a good time to start working on your Rule 49 initial disclosure statement, start working on your proposed resolution statement, and potentially make a settlement offer if you're in a position to do so. Now, what happens if the other side doesn't respond? Then you're going down this default route. So if no response is filed within the 20 or 30 days after the proof of service is filed, that's when you can file an affidavit for default. Wait the 10 business days. And if no response is filed after the 10 business days have run, that's when the opposing party is in default. So at that point, you either lodge a proposed default order establishing custody or request a default hearing. And at your default hearing, preparing a proposed default order and presenting it to the judge is very helpful. But you've got those two ways to resolve a default, either with or without a hearing. So you want to pursue the avenue that is appropriate for your case. Okay, that brings us to the end of the summary video and to the end of this series on how to initiate a case to establish custody. Thank you.